All right, you wanted time to look at that case?
I did look at it, Your Honor. It deals primarily with civil matters, obviously. And I think.
Can you turn your microphone on, please?
Pardon me. I did look at the case, Your Honor, and I believe it clearly deals with civil matters. I think what the court in our discussion has identified are really three issues to be analyzed. The court did analyze the first issue, and that had to do with the question of whether this was admissible or not. We did do a little bit of research. I don't know if the court will allow me to even address that again, or if you would, I would refer the court to a local case called Sailing, which holds that, although it has been held that statements which merely narrate past events are not to be deemed to be made in furtherance of a conspiracy. And then it does say that the court has to do a balancing analysis. The site is 7cal.3d at 852. So we would certainly renew our objection to the admission of the statement the witness purportedly wants to testify to. Number 2, the question is, does the Shield Law apply? And if the Shield Law is deemed by the court to apply, I believe you still have to then do another balancing test to determine, in a criminal trial, if the defendant, to get a fair trial, has a right to crack what is being shielded. And I would refer the court to the case of Delaney versus Superior Court, 50cal.3d 785. It's a 1990 case. And you have a holding that, to overcome a prima facie showing by a newsperson that he is entitled to withhold information under the Shield Law, a criminal defendant must show a reasonable possibility the information will materially assist his defense. A criminal defendant is not required to show that the information goes to the heart of his case. Now, I think the prosecutor has basically admitted that he thinks the purported testimony goes to the heart of his conspiracy allegation. He believes it goes to the heart of his conspiracy allegation as it appears in the indictment and as it appears in the alleged overt acts in the indictment, according to the prosecutor. The question we have, or the question for the court is, if he's allowed to bring in this hearsay statement, or I think the court considered it an admission as well, what are we allowed to do if we want to cross-examine him? And I think it's pretty clear that the witness and his attorney are attempting to preclude any type of examination into his relationships with the people he wants to testify about, relationships which he identified and articulated to 2 police officers. And I renew my claim that we would be severely hamstrung and prejudiced in our ability to examine him for the truth of what he is saying and his motives for saying what he's saying if we couldn't go into that. So where we are right now, Your Honor, is, I think there's an argument that it's shielded based on the case the court read, but there is a far stronger argument that the defense must go into that information if the witness is allowed to testify. So perhaps the better solution, weighing all of these issues, is disqualify him from testifying, and then there is no argument that the defendant is being unfairly hamstrung in his ability to confront and cross-examine. And I don't think. One thing I will say to the court, in his interview to the police, it appears as if he's giving all of the information. As I understand, a lot of these cases dealing with the Shield Law, they have to deal with information gathered by the reporter that the reporter doesn't want to disclose. Here, you've got police interviews where basically the police appear to be saying nothing, giving him no information at all, and he is voluntarily allowing himself to be interviewed, near his place of business, about Schaffel, about Konitzer, etc., about the Arvizos.
But, see, that's the material he's gathered. It's not, he wasn't gathering from the police, or if he tried, he apparently failed. He had already gathered his information, and he was telling the police what he'd gathered. And.
But it does involve more than that, Your Honor. He admitted to the police working out of Schaffel's home for weeks, for example. Things like that are part of that interview and are part of the information his lawyer wants to shield. And it would just eviscerate our ability to probe and test for credibility on cross-examination if we couldn't go into those relationships and that information.
Well, under Delaney, you have to show. The defense has the burden of showing that the information, the unpublished information that he has, would materially assist the defense. And,
as I just said, Your Honor, I believe the holding is just if we show a reasonable possibility it will help us to assist the trier of fact in determining whether this witness should be believed or whether this witness has a motive to lie or a motive to gain financially by appearing in this trial, by saying what he's saying, given his past associations, his past admissions and statements to various people. If we can't go into that, we are severely prejudiced.
Well, what is the information that you claim that he has that would materially assist the defense? And it says you must make a specific showing that the non-disclosure would create a substantial probability of injury to the defendant's right to a fair trial. What is that information that you think is that valuable?
His relationships with Konitzer, when he met him, how many times he spoke to him. Did he have any financial connection with Konitzer? To his knowledge, was Konitzer involved with Schaffel when he was involved with Schaffel? What business relationship or financial relationships did he have with these two people? Why was he trying to get information from them? What did he intend to do with the information? When did he last talk to them? Did he, in fact, talk to the police voluntarily and give information to try and be part of this case, because he is a journalist and he can profit that way? I mean, there are lots of questions that I would want to go into about his relationship.
There's lots of questions, but what is the information you would get that would? It's not the questions that prove the point. It's the answers.
Yes. Well.
So what are you offering? What are you proffering to me in the way of information he has? Not questions you have.
He's had a falling out with Schaffel, who he had a business relationship with. He worked out of his house for 3 weeks. He saw a contract at Schaffel's saying Schaffel was going to make millions of dollars. He was not allowed to participate in that. He had a falling out with Konitzer. Is he now trying to basically assist the prosecution in incriminating Konitzer? He has a lot of relationships with these two characters that I would think we have to be able to go into to show his motive to lie.
You're making an offer of proof that those facts are. If he were forced to testify, he would say that he had not been able to enter into multi-million-dollar deals with them, etc., etc.
Well, he may deny it. But if he does, I would explore it further and show he's not telling the truth.
Okay, well, what I want to know is what you know he has to say, not what you suspect from your questions.
Well, Your Honor, I've never interviewed him.
You have the police interview.
Yes, I do.
That would be of some assistance, I would think.
Yes, Your Honor. He worked out of Schaffel's residence for approximately 3 weeks. He learned that Schaffel was trying to enter into a contract with Fox for $7.5 million regarding the Roe interview. He conducted the Roe interview. He told the police the Roe interview was not scripted. He apparently didn't make any money off of the Roe interview and apparently wanted to. He met Konitzer, who was also involved in the Roe interview. He had a relationship with Konitzer. They apparently talked on a number of occasions. He was in Florida with these individuals.
I think what we should do is, some of those things may not be subject to the Shield law. Some may. The district attorney has finished his examination. I've made the ruling, which I'm not changing, on the state of mind that. So now the question arises under Delaney. So, in order to find out where we really are under Delaney, I think you have to ask the witness some questions, and we have to see which ones he answered and which ones he claims are unpublished and he has a privilege, and I'll have to look at the case from that standpoint.
Okay.
And the only thing I would like to add, Your Honor, is under the Delaney test, the test that.
You need to.
I'm sorry, Your Honor. I'm not used to using these microphones. Under the Delaney test, it's not only the threshold test, which is what Mr. Mesereau presented, of whether the information sought is reasonably likely to materially assist the defense. That's simply the threshold. Assume he gets past that. Then the court engages in a balancing of all the other factors in Delaney. It's not simply enough that he meet that one test.
That's right. Then we look to see the balance, I agree. So you may question.
Thank you, Your Honor. Mr. Drew, do you know someone named Marc Schaffel?
I did.
You did?
Uh-huh.
When did you first meet Marc Schaffel?
Your Honor, I'd object to the extent that reveals unpublished information. And also point out, Your Honor, that really has very little relevance to the one statement that Mr. Drew has been asked about by the prosecution that was published. You're now talking about an entirely different individual, not even the individual that he has spoken to that he talked about in his interview.
With all due respect to counsel, that's not true, Your Honor. I will link the relationship he has with Schaffel and Konitzer to the impeachment I'm trying to demonstrate. But I could ask the questions on Konitzer, and I'll see if he's going to assert the privilege to those. Maybe that would narrow it. Shall I do that, Your Honor?
Let me think. He's already testified that he was working for Konitzer when he did the interview, right?
Actually, I don't believe that's correct. I believe he testified he was working for a magazine and the interview was set up through Mr. Konitzer and Mr. Schaffel, not that he was working for them. And in fact, I think he testified, and counsel will correct me if I'm wrong. I believe he was asked was he paid anything by them, and he said no. Nor was he working for Mr. Jackson at any point.
All right, for purposes of where we are in the hearing, I'll sustain the shield objection on that question.
Do you know someone named Ronald Konitzer?
Yes.
And how long have you known Ronald Konitzer?
Same objection, Your Honor, to the extent that that's not been published, the extent of the length of their relationship or knowledge. Simply the fact that he knows him has been published.
Well, I think I need you to be more clear in your objection. You're saying, to the extent that that has not been published. I mean, you have to make a claim that that's not been published. That, Your Honor, that has not been published, so I know that. I don't really know that, the way you're stating it.
I apologize, Your Honor, and the only reason I'm couching it the way I am is because Mr. Mesereau seems to believe that some things are publications which I don't agree with and the court hasn't ruled on. There is an interview that does not contain the information that Mr. Mesereau is asking about, and that's the publication that we're looking at. That information is not published, as far as I'm aware.
Well, I don't think you can limit it to that interview. I mean, if he's published it anywhere, in any magazine, or any news, or TV, or, the definition really doesn't even involve media. I guess if it's dissemination to the public, he could do it personally walking around the mall over there. So we have to, when you claim he's being asked to reveal something that he hasn't published, it has to be he hasn't published it. Not that he didn't talk about it in the interview with the, which interview are we talking about?
The court TV interview, Your Honor.
The court TV interview that he was interviewed on. That is not the only place that he could have published. He may have published it nowhere else, but we need to be clear. We aren't limiting this to that.
I understand, Your Honor. And so my objection is that Mr. Mesereau is calling for information which is unpublished within the meaning of the Shield Law.
All right, for purposes of this hearing right now at this point, just to see where we're going, I will sustain the claim under the Shield Law.
When did you first meet Ronald Konitzer?
Same objection, Your Honor. That's unpublished information.
All right, for purposes of this hearing right now, I'll sustain that claim under the Shield Law.
Where did you first meet Ronald Konitzer?
Same objection, Your Honor.
All right, and I'll make the same ruling for purposes of this hearing.
When you first met Ronald Konitzer, who else was present?
Same objection, Your Honor.
I'll sustain the objection under the Shield Law.
When you first met Ronald Konitzer, in your mind, what was the purpose of the meeting?
Same objection, Your Honor. Also that Mr. Drew's state of mind is not at issue here.
I think it is on cross, Your Honor.
I'll sustain it under the Shield Law.
How many times have you met with Ronald Konitzer?
Same objection, Your Honor, as to unpublished information.
I'll sustain the objection under the Shield Law.
Have you ever discussed Michael Jackson with Ronald Konitzer?
And I would object to the extent that it seeks information that has not been published.
That's an insufficient objection. I'll overrule it.
I understand, and the only reason I'm couching it that way is the question, as phrased, is ambiguous. But I'll object to the question as calling for information that is not published.
All right, I'll sustain that under the Shield Law for this hearing.
Have you ever had a discussion with Ronald Konitzer about the possibility of interviewing the Arvizo family?
Yes.
When did that discussion take place?
It took place the week after the Debbie Rowe interview.
When was the Debbie Rowe interview?
I believe, from my recollection, it was March of 2003.
Were you at the Debbie Rowe interview?
Yes, I did the Debbie Rowe interview.
Are you the person who asked Debbie Rowe questions in that interview?
Yes.
You've told the police that interview was not scripted, correct?
Your Honor, and I'd again object that this is not published information.
And I would also interject an objection that it exceeds the scope of the direct examination.
You guys have to use the microphone.
I would object that it exceeds the scope of the direct examination.
Sustained.
Was the Debbie Rowe interview scripted?
Same.
Objection. Exceeds the scope of the direct examination.
Also unpublished, Your Honor.
Sustained on both grounds.
Was Ronald Konitzer at the Debbie Rowe interview?
Objection, Your Honor. Calls for unpublished information.
Sustained under the Shield Law.
Now, you said, in response to the prosecutor's questions, that Mr. Konitzer referred to the Arvizo family leaving Neverland Ranch, right?
Yes.
And your first response to the prosecutor's question was that Konitzer told you that they had disappeared from Neverland Ranch, correct?
Yes.
After being further asked questions by the prosecutor, you said that Konitzer had used the word escape, right?
I said I believed he had used the word escape. I remembered it.
You didn't use the word escape when you first responded to the prosecutor's question about what Mr. Konitzer had said, right?
I think I did. I think it was all within the same sentence, from my recollection.
You said, disappear, did you not?
That was part of it, too.
Now, how long did your discussion with Konitzer take place on that particular occasion?
Objection, Your Honor. Calls for unpublished information.
All right. Sustained under the Shield Law.
Were other things said by Mr. Konitzer to you on the occasion when you claim he made that statement?
Same objection, Your Honor. Calls for unpublished information.
Sustained.
How long did that discussion last?
Same objection, Your Honor.
Sustained.
Did you say something to Mr. Konitzer in that discussion?
And I'll object, Your Honor, to the extent that it calls for information that has not been published. It was one word, I believe, Mr. Drew has published, which I'll let him answer.
All right. Answer the word, following your attorney's instructions.
If you recall.
I don't remember.
Where did the discussion take place?
Same objection, Your Honor. Calls for unpublished information.
Sustained.
Who else was there with you and Konitzer?
Same objection, Your Honor. Also assumes facts not in evidence.
Under the Shield Law objection. All sustain the objection.
Was anyone else there with you and Mr. Konitzer?
Calls for unpublished information, Your Honor.
Sustained.
Did you arrange for the discussion where you claim Mr. Konitzer made that statement?
I believe it's vague, Your Honor, but it's information that is published, so I'll let the witness answer, if he recalls.
Yes, I was trying to get an interview, so I think I made the phone call, because I'm pretty dogged about that usually.
Where were you when you made the phone call?
Calls for unpublished information, Your Honor.
Sustained.
Did you call Konitzer's number?
Same objection, Your Honor.
Sustained.
Your Honor, I believe at this point it's pretty clear I wouldn't be able to cross-examine the witness on any of this, we would be prejudiced. And I believe, under the Delaney case, the witness should be disqualified from testifying. I'm not being allowed to cross-examine on anything regarding the bona fides of what he said and in what context it was said, who was there, where it took place. And again, I would refer the court to the holding in the Delaney case. All we have to show is a reasonable possibility the information will materially assist the defense. And the material assistance would be in examining the veracity, the motives, the bias of this witness.
And, Your Honor, I believe under the Foss case, that disqualification of the witness is the appropriate measure to take rather than allowing any counsel to get into information that clearly is protected by the Shield Law, so that even published information should not be presented if then, to allow cross-examination, would delve into constitutionally protected information.
Mr. Drew?
Uh-huh.
I'm looking at the testimony you've already given. What I want to do is read to you what you said about just that one sentence is all we're talking about. I want to read to you that sentence, and I want to ask you a couple of questions about why you said that sentence.
Okay.
But to do that, I want to read it to you, so I'm going to ask you to listen to this. The question by Mr. Zonin was, what specifically did he say with regard to the disappearance of this family? Would it be helpful if the witness was given a transcript of the television program? We can do that. I say something, and then Mr. Zonin says something. And then Mr. Zonin says, well, as a question mark, and you say, it's a simple enough question, I think. I was told that they had disappeared, that they couldn't keep them there anymore. There's some objections, and you say, and I believe the word, escaped, was used. But again, I can't say word for word. But from the best of my recollection, yes, I heard the word, escape. First of all, what you've already answered, does that accurately reflect your recollection of that conversation?
Yes.
What is your? If you can answer this, what is the failure of your recollection about the word, escaped?
No, it's to the best of my recollection. When I was talking to Mr. Konitzer, I was simply I was on a deadline trying to get an article done, so I wasn't paying attention word for word, knowing that in a trial 2 years later I would have to remember each part of it. I remember the tone of his conversation more than I remember even the exact words.
Okay, thanks. Mr. Mesereau, is there anything in the police reports that you have that you would like to represent to me?
First of all, Your Honor, as the court knows, in many of my prior cross-examinations of witnesses, I have asked them when they, if they ever met with any representative of the Santa Barbara Sheriff's Department. Who initiated the meeting? What was said? Who said what? Did the sheriffs say anything to you about the case? And the reasons are obvious. We want to establish if, in fact, the prosecution or its agents have tried to infect any witness with information of a specific nature or give them a perspective on the case or try and indoctrinate them in some way. We also want to establish if the witnesses have said anything to the sheriffs which suggests a desire to be involved in this case or a desire to.
I think you didn't let me finish my question.
Oh, I'm sorry. Pardon me.
The question I wanted to ask, is there anything in the police reports that he said in the interview with the sheriff's department or any law enforcement people that you want to show me or advise me of? You know, as opposed to the questions that you would ask, any information contained therein that you believe is, material that would.
Yes, Your Honor. I mean, first of all,
materially assist your defense if he were to testify to it?
Yes, Your Honor. There is the business relationship between this witness and Schaffel and Konitzer, as I would like to establish, is that he had a relationship with them. He was involved in their efforts to make money off of Michael Jackson.
That's, just to be clear now, that's in the police report.
Yes, Your Honor. He conducted the Debbie Rowe interview. He was working out of Schaffel's residence. He was promised he could interview the Arvizo family. He had a financial interest in working with Schaffel and Konitzer. He then was apparently told, you're not going to be interviewing the Arvizo family because they left Neverland. And then the question is, what kind of relationship did he continue to have with them? What money did he expect to make? Who was supposed to pay him for doing all of this? Did he think he was going to be involved in the Fox contract? He did tell the sheriffs that he saw, in fact, a Fox contract at Schaffel's residence during the approximately 3-week period of time that he worked out of Mr. Schaffel's residence. And the question would be, why did he look at the contract? How did he know it said $7.5 million from Fox? What interest did he think he had? Has he had a falling out with Konitzer? When did he last talk to any of these people? He did not obtain this so-called quote in isolation, and he didn't obtain it in a casual, unexpected occurrence or meeting. He obtained it, if he did, within the context of an ongoing business relationship with Konitzer and Schaffel, who the prosecution allege are unindicted co-conspirators. And the motives for coming forward and making this allegation on TV and in court are fertile ground for cross-examination, where the scope of cross-examination is very broad to show any type of financial motive, financial bias, or a bias to say anything that hurts his former co-business partners, which in fact they were. So we would be severely hamstrung if we could not go into these relationships and these motivations. Now, he told the police that when he interviewed Debbie Rowe, he was working out of Schaffel's residence for approximately 3 weeks. He said that during that period of time, he saw the Fox contract. He just told the court that when he got this information from Konitzer, he had a deadline. How did that deadline relate to why he was talking to Konitzer to begin with? What project were they still involved in, if any? And clearly his police interview, which was conducted by him, as I said before, on a voluntary basis, talks about how he met these characters, how he stayed in contact with them, where he called them from, how the interview with the Arvizos he thought he was going to do related to the interview with Debbie Rowe. It's all part of the same package. And, Your Honor, there are tapes where he and Debbie Rowe complain about Schaffel and Konitzer. There is the issue of his falling out with them. It's all interconnected.
Okay. Do you want to be heard, Mr. Zonin?
Your Honor, the police report in this matter is 4 pages of text, and I think it would be appropriate for the court to review it, and I would invite the court to review it to make the determination as to whether, would you like me at the podium?
Yes.
The court specifically made the inquiry as to whether or not there's information contained in the police report as might justify extensive cross-examination of this witness with regards to information given by the witness to detectives in the course of that interview. Rather than debate what is and what isn't, it's a very brief report. It's only 4 pages of large script. And I would ask that the court read it to make a determination as to whether or not that would assist the court in its judgment. Once again, the prosecution is offering 1 sentence in this case. It's a conversation that took place between this witness and another person, one of the unindicted co-conspirators, to the extent that person said to this witness, "They've left," and the words of how they left. It's effectively 1 or 2 sentences. I do not believe that warrants and justifies extensive cross-examination on the relationships and interrelationships between each of the 5 unindicted co-conspirators and this witness and any of the co-conspirators among themselves at any point in history. I also don't believe it justifies an examination into his involvement in the interview with Debbie Rowe, which was an entirely separate interview and separate people involved. As to the question of what he can be cross-examined on in the course of the interview with the 2-sentence conversation with Mr. Konitzer, I think that he can be cross-examined on information that would shed light on what was going on at that time and the accuracy of that statement, and it is a statement that is relatively non-controversial. It is not the type of thing that a thorough examination of the relationships of these parties would necessarily disprove or as to motivation. And so I believe that until the defense satisfies the burden, which they have, for the purposes of showing that there is information out there, and they're not simply on a fishing expedition, but that there is concrete information that would somehow show that this statement was never made, or, if it was made, had a different meaning, or in fact was a statement that's entirely different from what it was as it's represented by this witness, and I believe that they can do that within the limitations of the court and within the limitations imposed by the Shield Law. I have the report to turn over to the court, if that's permissible.
If I may, Your Honor, there are other reports as well. There's a number of pretext phone calls where he discusses the same issues identified in that police interview. I suspect Miss Sager is going to say they're privileged, but they do relate to the same facts. They give us a good faith basis, in addition to what I just told the court, to inquire into his relationship with Konitzer and Schaffel, and what his expectations were, what happened to the money he thought he was going to get, etc. I think the court would have to look at those as well. There aren't that many of them and I have them with me. I also have transcripts of those pretext phone calls.
And do both of you agree and stipulate that I can review those reports in conjunction with reaching a decision on this?
Yes.
Yes, Your Honor.
All right. Would you provide those to me?
Yes.
Your Honor, we have not been provided with those reports, and for purposes of arguing this motion, it would greatly assist me, if the court is going to consider them, if we also were allowed to review them.
Certainly.
I will do so.
You can step down. There's no sense in sitting there while we're trying to figure this out.
How clean are your copies?
They're pretty clean.
Do you just have yellow highlights?
Yeah, but also, there are transcripts as well.
You don't have material written into them?
Not really, no.
Okay.
It may take a moment. I'm just trying to staple these reports together, Your Honor.
All right. I think what I'd like to do, Lieutenant, would it work all right, when I take these back to read, if I declare a recess? And then you can. So these folks don't have to sit in here? Is that all right? And then we can bring them back in. It looks like I'm going to be a few minutes reading.
That's fine, Your Honor.
That would give them 5 minutes notice to bring them back into the courtroom, or let them, back in the courtroom.
Your Honor, I might add that this witness's name comes up in other reports dealing with interviews with other individuals and investigations into other individuals. Information regarding this witness was seized at Schaffel's house, for example. So I don't want to suggest that the scope of examination or the good faith basis for questions about his relationship with these people are purely based on what I'm giving you. There's other stuff, too.
Okay.
May I approach?
Yes. All right. Then we'll take this recess. Counsel, would you like to retrieve the police reports?
I can get them.
Thank you, Your Honor.
All right. The court is going to make the following order. That the court finds that the probative value of the statement offered by Mr. Drew is questionable. That if the statement was introduced into evidence, the statement might lend itself to proving somewhat the conspiracy. But the only value I see of the statement, the only evidentiary value of the statement would be to prove Konitzer's state of mind, which is not Mr. Jackson's state of mind, and may very well not be appropriate to admit under any circumstances. Because even though it's a co-conspirator's state of mind, it would be unlikely helpful in proving Mr. Jackson's involvement. It wouldn't prove his involvement. In addition to that, there is some real vagueness in the statement as recalled by the witness, since he does not recall exactly what was said, but more the sense of what was said, and isn't sure where the word escaped fit in. Considering these items, in balancing under Delaney, the court does not believe that the shield law is overcome in this case. The shield law then remains in effect. That effectively bars the defense from cross-examination on the statement which I've already determined to have some questionable value. Therefore, the court finds the only appropriate remedy is to deny the people's request to admit the statement.
Your Honor, we have no further witnesses for the day.
What I would like to do is excuse the jury. There's two ways to do that. Probably the cruelest way would be to
Send the bailiff in there?
file them in here and then tell them. In fact, I don't think I could face them. Laughter. No, I better face them, though. Let's bring them in.
Your Honor, is Mr. Drew excused?
I'll be a man about this. Yes, you're excused.
Thank you.
It's my custom to not be on the bench when the jury comes in, so I think I'll leave. Good afternoon.
In unison, good afternoon.
To counsel, you tell them. Laughter. Because of rulings that I've made today, we have no further witnesses. I am advised by the district attorney that they have 2 days left in their case, Monday and Tuesday, and they will be full days, without delays. So I apologize for keeping you here all day today like this. I didn't anticipate, of course, the length of time that was going to be involved, and I tried very hard not to do that to you. I know how crummy it is to sit back there and not have anything to do and not know what's going on, and it's just one of my things I just don't do. And we have gone through a lot of days without doing that to you, so I'll try to get through a lot more before it happens again. So I'll see you next week. Court's in recess.